Hello and welcome to the latest webinar in the Innovative Law Practice Techniques series. My name is Austin Conley and I'll be the technical operator for this webinar. Before we start the program, I would like to provide some housekeeping information. Today's webinar is a special collaboration between the American Bar Association and the New South Wales Bar Association. This webinar is being brought up to you by two professional organizations live across the Pacific Ocean, the Law Practice Division's Legal Project Management Interest Group and the New South Wales Bar Association's Cost and Fees Committee. Our speakers are based in Jackson, Mississippi, Detroit, Michigan, and Sydney, Australia. Our moderator today is Australian barrister Philippe Doyle-Gray, who is also a member of the Law Practice Division's Governing Council. During the presentation, if you have any technical problems, I'll be happy to help you. Please enter your problem into the question box on the webinar panel on the right side of your screen. I'll respond to your technical issues without disturbing the panelists. Although we will have a live Q&A session during the last 10 minutes of the program, we encourage you to ask questions or post comments throughout the presentation. You do this by posting a message into the question box on the GoToWebinar panel on the right side of your screen, the same that's for technical issues. Moderator will try to ask all questions on your behalf, and if several people are asking similar questions, he will do his best to represent all perspectives. Finally, a reminder, this program is being recorded. To view a recording of this or other presentations which might interest you, I'll give details at the end. With that, I'll hand things over to our moderator, Philippe Doyle-Gray.
Welcome everyone, and thank you for joining us. I'd like to begin by asking you to type something into the question box on the GoToWebinar panel, which you should see on the right-hand side of your screen. What I'd like you to do, if you're in the audience, is tell me where you're physically located right now. If you could give me a city, a state, and a country, I'd be very grateful. So, lawyers on both sides of the Pacific have a lot to learn from one another, even though traditionally American and Australian lawyers didn't have much to do with each other. For over 5 years now, I've had the pleasure of meeting many US attorneys, and I have been surprised at how similar it is for them and us to practice law in the United States and in Australia. As some of you know, my interest is in the application of information and communications technology to the practice of law, but the similarities across the Pacific between us go much, much further. And this really shouldn't surprise anyone. We both speak English, courtesy of the British. We both inherited the common law system, courtesy of the British. And finally, also courtesy of the British, we share a common pleasure and bond every chance we get in beating them. Today's webinar is about a universal client concern, money. It's usually one of the most important things to our clients, and it's one of the hardest things for lawyers to estimate. Legal project management is a vast topic, but its essence is simple. It is a planning process that improves outcomes, and it is a skill which everyone can learn. Today, we will only be touching upon a few aspects which will be developed further in future seminars. It's just about money today, how to develop a reasonable estimate of fees. We'll be covering 3 topics. The first is, what do American and Australian lawyers have to learn from each other? The second is, what is legal project management and how do we implement it in our day-to-day lives? And third, how legal project management helps to recover fees for successful litigants. Now, before we start, I can see people from all over the world. Thanks very much. I can see people from Calgary in Canada, Northbrook, Illinois in the US, Montreal in Quebec, Canada, Port Macquarie here in New South Wales, Houston, Texas, Sydney, Australia, and I can also see a familiar name of someone in New Zealand. Welcome to you all. All right, so what do American and Australian lawyers have to learn from each other? Fiona O'Loughlin is General Counsel for Rexel Australia, an electrical wholesaling business and part of the global Rexel SA group based in France. She holds degrees in both science and law from the University of Sydney. Having worked as a commercial and technology lawyer for the Australian top-tier law firm Allens in Sydney and Silver Circle law firm Herbert Smith in London, Fiona moved into legal practice management in the early 2000s. She's particularly interested in the convergence of legal compliance, risk and governance systems. Fiona, from the perspective of an Australian in-house counsel, how do legal costs and fees work for you?
Well, I think they're obviously one of the challenges of the role. And I guess that's because they're very closely related to the overall process of budgeting in an organisation. And accountants like things to be predictable, and so frequently we're asked to contribute to the budgeting process at the start of the year, and then are in some way held accountable for divergence from that budget. Although, to be fair, none of my finance colleagues have ever held me accountable for the fact that, you know, we've been hit by a piece of litigation that we couldn't see coming. But I do find that different internal customers have a different capacity to bear legal fees. If you've got a division that is a low margin division and very infrequently uses lawyers, they do find it very difficult to understand the value and accept the cost into their budget, which is very probably quite bare to start with, unlike an M&A or a strategy department who are doing M&A transactions frequently and are very comfortable with a reasonably high level of fees. So that's certainly been one experience that I've had from an in-house perspective. The other one is around working for a global company. Obviously, in different jurisdictions, the sort of fees that you face when you're in a piece of litigation can vary quite enormously. So I have an example where we were involved in some regulatory litigation last year, and our fees were 7 digits, whereas my French counterparts who operate in a very different system said, and I can only accept their view, that they thought the litigation should cost about 50,000 euros. That's a vast difference. So that's where unpacking how the matter unfolds and what the process is really useful in explaining to those people how we end up with such enormous numbers. And that's obviously part of my role, supported by external lawyers and barristers to help unpack that in advance. And I suppose the other part of that is just being able to predict what's going to happen in the matter, and not to the nth degree, but at least know that there are some decision points that the client's going to face, and what the alternate outcomes mean in terms of fees as well as in terms of the legal strategy of the case. So I guess that's been my experience, particularly with litigation here in Australia, and that's where I think legal project management has a lot to offer us.
Sounds like, Fiona, what you're saying is that just like everybody else in the world, you have people that you need to report to and you're given parameters, and part of your job is explaining complex ideas to people who don't understand, perhaps from other parts of the world. Is that right? Absolutely right.
I think that in every firm that I have, organisation that I have worked for, there is an expectation that there will be a fee estimate up front. And in fact, to be fair to the profession, I think we've got so much better in the last even 5 years than we were, you know, when I started practice 20 years ago now. So we have come a long way, and I think this is just part of the next generation of getting even better at it. I think one of the things that I'd love to see in the next iteration of legal project management is collection of data at the end of the process. And I know many firms are doing that in their listening programs, to actually one day, you know, if we get enough, have a big data response on what's likely to unfold in a matter. We'll actually use, going back to my scientific roots, actually use some scientific research to benchmark where we are and where we're likely to go, having had a look at how many cases have run. Of course, as a lawyer, it depends. So no two cases are ever identical, but I think that's one of the areas that as the rest of society moves that way, we will be expected to be able to offer that sort of insight.
And just finally, those of us who are in private practice, how should we interrelate with C-level suite people who are lawyers? Should we expect them to be experienced litigators and to understand our language, or should we adapt how we're dealing with them?
Look, I think here in Australia, my experience has been that general counsel of most organisations come from a commercial and corporate M&A background. They're not typically litigators by experience, and so probably are less sophisticated than you are, certainly in the art of the court rules and some of the niceties. And I think where that's really bites for me is around evidence, because they're very good at understanding the legal theory of the case, but I actually think it's understanding how you can come undone in presenting evidence or in actually having sufficient evidence to make your point. That's really important to understand at the front of the case, because that affects the sort of decisions that you make about how strong your case is likely to be should you take it to court.
Thanks so very much, Fiona. We might now move to an American client perspective. Pat Ellis. Patrick, you serve as counsel to Maven and Mobility Solutions at General Motors in the car capital of the world, Detroit, which we can see is experiencing now beautiful fall weather in the background. Your unit is part of GM's Global Markets, Autonomous Vehicles and Transportation as a Service group, so it's absolutely cutting edge. You're personally responsible for providing general counsel to a spectrum of mobility as a service solutions. And you previously worked at GM's Office of the General Counsel as a business planner, where you were responsible for the project management of strategic programs and initiatives at GM. But you've also got experience in the private sector, because before that you worked as a legal project manager at Heineman, Miller, Schwartz & Cohn LLP in Detroit. And I believe you were the firm's first legal project manager. And part of your duties was that you had to develop and implement the firm's methodology and its deployment of project management for client matters and portfolios. So, Pat, from the perspective of an American in-house counsel, how do legal costs and fees work for you?
Thanks, Philippe. And thank you to the ABA and the New South Wales Bar Association for putting this panel together. I'm really honored to be a part of it. I would echo a lot of what Fiona mentioned. The one thing that really struck me and has sort of continues to strike me as I'm relatively junior in my career with GM and in my legal career generally, that we often, when I was working at the law firm and when we talk about legal fees, we often think of the in-house counsel as the client. It's kind of like that's where the dollar stops. But of course, coming over and practicing in-house, a significant realization is how, while we, our outside counsel, are accountable for fees and costs, in-house counsel is equally, if not more, responsible for managing those costs, bringing predictability to those costs for our clients and business partners. Ben Heineman, the former general counsel of General Electric, wrote a great book recently, and maybe we can share a link with the audience after, but it was called The Inside Counsel Revolution. And he has a great quote from that book, and I'll just, if I can, read that. He notes that in-house lawyers are driven by the endless corporate drive to do more with less, increasingly exercise control, often seeking to restrain and refocus law firms' spend to deliver high value at a fair price. And that's kind of what I think the challenge is for in-house counsel when we're talking about fees, is how do you do more with less? And I think if you kind of memorize that little phrase, whether you're inside, outside, wherever you are in the equation, you'll really kind of understand what drives in-house counsel from a fee perspective, and what the incentives should be for lawyers when they're thinking about managing costs. So that's kind of the high level view from my perspective.
Now, I know that because you've had experience on both sides, one of the things I've heard you discuss before is the DuPont legal model. Can you explain what that is and how it might be implemented?
Yeah, so this idea of doing more for less in a corporate legal environment, is certainly nothing new. DuPont, I believe, now I'm gonna have to maybe correct my history here, but Tom Sager was sort of the pioneer of this model at DuPont, in which they looked at their legal service providers, their law firms, and they tried to narrow that group down to a panel of law firms that they could have a really strong relationship with. Getting that kind of consolidation drives efficiency around fees, effectiveness of counsel, those kinds of things. And so I guess the point is here is that, all of these things that we talk about now, whether it's convergence, RFPs, alternative fee arrangements, these are things that in-house counsel have been doing for a long time. It continues to be something that is very important, takes up a lot of my time, and I think it's something that is valuable to understand whether you're inside or outside.
So Pat, one of the things that you've been focusing upon is cost control, which perhaps sounds a bit like a euphemism for we want you guys in the private sector to charge less, which is nothing new from all clients. From your perspective, how could a practitioner who's dealing with an in-house counsel talk about costs using legal project management to get the conversation away from reducing rates?
I think that from where I sit now, and looking back on my experience working at Heineman as a legal project manager, sometimes it helps to have documentation or tools or data to kind of support the gut feeling or the intuition or the experience that attorneys come to develop over the course of their careers. I think being able to talk about your matters sort of at the legal, the regulatory, the kind of the high level, the procedural is all very important. But if you can also accompany that with a budget or a project plan or a timeline, those things can really help kind of have that conversation with the client. And whether that client is an in-house attorney or an engineer or a CEO or a CFO, business people are used to seeing charts and graphs, timelines, project plans. It's something that I think, we see less of in sort of the legal profession, but those tools and aids can really help in that conversation. And I think that's ultimately what legal project management brings to bear on the practice of law. It helps communicate value and predictability and transparency in what it is that lawyers do for their clients. So, I think really legal project management at the end of the day is about communication, and certainly the tools within LPM can help facilitate that.
Right. Thanks so much, Pat. So I think it's pretty clear the client concerns are basically similar on either sides of the Pacific. The regulations which private practitioners have to operate under can be quite different, and I want to address those now. Mark Walsh, SE, you were admitted as a barrister to the Supreme Court of New South Wales in 1994, and you took Silk in 2015, and that's where, for our American audience, that's where the SC came from, stands for Senior Counsel. Taking Silk is a phrase we use in Australia because as a junior barrister myself, I wear a cotton gown, and Mark wears one worn of silk. So, Mark, your areas of practice now include general litigation, commercial disputes, contracts, torts, medical negligence, professional negligence, insurance and coronial proceedings. You're a member of the New South Wales Bar Association's Costs and Fees Committee. You're a contributing author to Thomson Reuters Civil Practice and Procedure, including the provisions on evidence and expert evidence, and you're a lecturer at the University of New South Wales, including at the Litigation Masterclass series. Mark, just briefly, because it's a complex area, from the perspective of an Australian barrister, how do legal costs and fees work in Australia?
Legal costs and fees, Philippe, are regulated by statute, and unlike the American experience, there's a fundamental principle in Australia, which is that costs orders are made in litigation such that the loser pays a substantial amount of the costs of the successful litigant's outcome, or the costs incurred for that. The legislature has stepped in and regulated costs, very much picking up the themes that Fiona and Pat have addressed, and to ensure that clients of legal practices, be they solicitors or barristers providing legal services, are able to make informed choices about their legal options and the costs associated with pursuing those options. Practices are regulated in recovering costs on the basis of an appropriate disclosure and entering into a costs agreement with the firms or the individuals, the litigants in person. So that structure imposes a very appropriate environment early in the litigation or before the dispute goes to the court to implement legal project management with the concept of case theory and identifying various aspects of the dispute. This is something that is across professions and perhaps common experience in our lives. And that is that problems need to be carefully identified before a solution can be crafted. The old approach of trying to bolt the solution onto the problem is no longer acceptable and is not cost effective. So legal project management is very much part of the future, and identifying case by case what is the most successful approach to a resolution for all the parties.
Thanks very much, Mark. That's a very neat summary of a very, very complex area. Can I ask you then, Mark, having heard what both Fiona and Pat had to say, how can Australian practitioners deploy legal project management within the context of that regulatory framework and satisfy some specific needs that either Fiona or Pat referred to?
Thanks, Philippe. It's a very, very good question, and it's an important one for practitioners and for clients. Both can deploy these concepts extremely well, and it's part of the future. It's going from the old traditional practices into identifying through legal project management what a successful outcome will be for a client. And as we all know, that is something that vexes a lot of litigation. Surprises in litigation are poorly accepted. Legal project management and case theory approach to litigation allows the client and the practitioner, the team, if you like, to identify what a satisfactory outcome will be for the client, and the legal practitioner can feel comfort in having a goal that can be sought, which often will be amended as new information becomes available, to allow the final result to, in a sense, have been identified well in advance. So a practitioner can satisfy a client's needs for certainty within the bounds of disputes, which is always difficult. And in a difficult area, it probably identifies as best as possible the difficulty to make predictions in legal disputes, especially about the future, as it's often said. So it's a plan, it's an evolving plan, but it's a shared plan. So appropriate responsibility is held across the team, that is with the client and the legal practitioner. The legal practitioner is not expected to have a magic wand. The client's informed as to choices, informed as to whether to go to court or whether to go to alternative dispute resolution, or whether the dispute's worth taking on at all.
Thanks so very much, Mark. David Roof, just before I go to you, there's a question from the audience about, Pat, something that you raised. When you were talking about the DuPont approach, you mentioned RPs. Can you just explain what that is or what they are?
Yeah, our RFPs are requests for proposals. That's a concept that, you know, we use often here at General Motors, and the idea is that we, if we have a significant matter or portfolio and we want to source counsel to provide assistance on that matter, we will send out a document to various law firms or attorneys requesting that they submit proposals to us in response to our request for assistance. So that sort of helps us evaluate which of our outside counsel, law firms, or attorneys would be the best fit for a given project. And of course, the financial, information in that response is important, and you know, something we look at and give great consideration. But you know, even more so, we try to get at the expertise of the counsel, what kind of extra you know, things that the firm can bring to bear on a matter or for us as a client. So it's really just a way of selecting outside counsel.
Sounds like another acronym that we're all going to have to come to terms with. David Ruth, speaking of acronyms, you're a shareholder of the Jackson office of Baker Donaldson. It's one of the 60 largest law firms in the US, and you also serve as the firm's legal project management officer. You are also chair of the legal project management interest group in the ABA's law practice division. You've been a practicing lawyer for more than 18 years, and you are PNP certified through PMI, in addition to being certified in the Toyota Manufacturing Production System, known as Lean. You lead a team of attorneys and project managers to implement project management for all of Baker Donaldson's clients, in-house corporate legal departments, and disaster recovery programs, which I know from experience in your case can be very, very large. You're responsible finally for the development of the firm's patent pending legal project management model, and I believe you're also a co-author of a project management book. But David, before we move to the substantive issue, what on earth is PMP certified through PMI and certified in Toyota Manufacturing Production System?
Sure. Can you hear me, Philippe?
Absolutely.
Okay. I guess probably 7 years ago, when our firm recognized a need to start implementing operational efficiencies, we evaluated several non-legal disciplines, including project management and including process improvement, which is the foundation of the manufacturing production system. And we found that many of our clients were implementing those techniques as part of what they call the operational excellence programs. And so that in order for us to better understand how those methods work and possibly how we could integrate them into the practice of law, I have to credit our management team. They invested in me and several others on our team to become certified project managers through the Project Management Institute, which is a standard setting organization in the United States and internationally, and also to get trained on the Toyota Manufacturing Production System. And then I have to go back to something that Mark said earlier, you know, and you said as well, this is a skill that can be trained. And I don't know that every lawyer is going to need to be trained as a PMP or have the Toyota Manufacturing Production System training. And we recognize that too. Not every lawyer has the time to learn the details of those techniques. But the essence of legal project management, I believe, is not rocket science. It's much simpler, and it's something that we can all implement. And I think our law firm's development of Baker Manage and Baker Lean were an effort to, I guess, create hybrids that were simpler for our attorneys to use.
I'm not quite sure exactly what Toyota Manufacturing Production System, though, is, David. How does that relate to legal practice? Because it sounds like something to do with industrial manufacturing.
All right, so the way these two things work together, project management and process improvement, which is the essence Lean, you know, and I'm going to go back to something that my Lean sensei, that's my instructor for Lean, told me. You know, in order to really start evaluating how you can improve a process, you have to get control of it. Because a lot of us are kind of working haphazardly, ad hoc, and what project management does is allows you to get control of that project, to put some systems around it, to put some organization around it. But that's not really process improvement. That's just getting organized. What Lean allows you to do is then evaluate that project, look at all the sequencing of events, look at who's doing what, and look for the most optimum way to do it. And as Patrick talked about earlier, companies are now looking for us to do something more efficient, you know, apply efficiency to what we do. So what Lean allows us to do is look for opportunities to integrate technology, to integrate lower rate timekeepers, to integrate automation tools to help our service delivery be much more efficient. Hope that explains it.
Yeah, absolutely, very clear. Just before I move on to the next topic, very, very briefly, is there anything in the regulatory framework that affects US attorneys that might be different from what Mark Walsh was talking about in how we could use LPM to engage with our corporate clients?
Yeah, for us, it's a little different. So in the United States, we're under what is called the American rule, and it's aptly characterized. Each party pays their own legal fees. But what that means is that doesn't mean that we are free to operate without controls. And so what has happened in the past probably 10 years is that we've seen, as Patrick talked about through DuPont's model and other convergence processes, we're seeing much more pressure put on outside counsel to control their legal expenses, to implement processes that allow them to provide more predictability in that legal spend. So while we don't have the same structure that you do in Australia, there is still a momentum in the United States to get control of those fees.
Great, thank you. All right, let's move on to our second topic now, which is really what is legal project management and how do we implement it? Experienced lawyers, I think, have always developed estimates of fees. My first supervising solicitor did that by evaluating how thick the file was, and we've come a long way from that. Isn't legal project management, Pat Ellis, just another passing fashion? Why should I change how I practice law?
Well, I think on one hand, you know, it is legal project management, whether you call it that or not, is something that good lawyers have always done. Now, to what extent, we can debate that. But, you know, the idea of developing a fee estimate based on the size of a file or on, you know, well, this is how much the last three cost, so that's how much this one's going to cost. I mean, that isn't going to cut it anymore, and certainly not at, you know, for large corporate clients. And I think that's, you know, this trend is going to work its way downstream. I mean, quickly, one kind of instructive movie scene that I really like, and I think, you know, is helpful here is from Moneyball, or if you've read the book. But in Moneyball, you know, the baseball scouts were kind of evaluating players on, you know, on what they were wearing or what their spouse looked like, these kinds of things that have no relation to how well they play baseball. And in the same way, I think lawyers who develop fees based on one or two past matters or the thickness of a file or, you know, these kind of gut feeling, intuition things, it's not enough anymore. And I do think that there's merit to those things, but you know, you need to augment that experience, that intuition, with something on paper, with data. So that's, to me, what legal project management brings to the table. Thanks,
Pat. Well, that's the American client's perspective. Let's go to the American lawyer's perspective. David Roof, what's in it for me? I'm trying to develop a reasonable estimate of fees. What has LPM got to offer?
You know, I started my practice 20 years ago, and like Fiona, you know, I never really bumped into a client requiring a budget until I did some work for a developer who was used to having itemized budgets for their construction projects. And so that was the first time I experienced it. And, you know, we really, as lawyers, haven't been trained on how to do thorough due diligence to build a accurate budget for our clients. I mean, it's kind of like my contractor client. You know, would you have somebody build you a house based upon their general guess of what it costs, or would you want them to provide you with a thorough estimate that's based upon the material, labor, permits, and effort required for the project? And so for what legal project management does for us is it provides us with a framework to develop that more reliable estimate of services. And it starts with, as Patrick said earlier, it starts with developing a plan, clarifying the scope of services that the client expects from us. And I want to make a point here too. It's truly a collaboration. This is not something that we go into a back room and develop. It's got to be a collaboration. And then once the scope of the representation is confirmed, and we can develop a more reliable estimate from that, there's other components of LPM which help us more proactively manage the engagement. Don't just throw that budget in a drawer. Actually use it as a management tool to ensure that we deliver this good service, good quality legal service, but also at a cost that the client expects. I want to address the question of whether it's a flash in the pan. In my opinion, legal project management is really at the core of our ethical responsibilities as a lawyer. In the U.S., ethical obligations are governed by local bar ethics codes, which incorporate concepts of informed consent, reasonable fees, and communication. And to me, legal project management provides us with a framework that we can integrate into our service delivery that ensures that for every case, we are meeting those objectives.
So, David, I've got a question for you, which is about managing the unpredictable. What I sometimes do when I have clients who say, am I going to win this case and how much is it going to cost? I pull out my crystal ball, which I keep in my drawer, and I say, take a look for yourself. But let's find a better way with LPM. So how does LPM allow us to manage the unpredictable? Is that just an equivalent for a contingency fee or a percentage?
I don't think so. I mean, I've experienced the same thing in my practice. And, one of my nightmare cases that I had was a case where I was representing a developer, and he asked me for an estimate. What's it going to cost at the front end? And I threw a number out. It was based on, prior 4 or 5 cases that I had worked. What I didn't consider was this case had a lot of nooks and crannies that had I engaged in a further discussion with that client, I probably would have uncovered and could have provided him with a much more accurate estimate of the legal fees. And so, to me, dealing with the unpredictable, if you can enter into a collaboration with the client to develop and gather more information about the services you're going to provide, you're actually going to give that client an opportunity to think more thoroughly themselves about what they want you to do as their lawyer, and possibly you're never going to be 100% accurate, but you're going to start out with a much better estimate. And then, in my experience, going to the client and talking to them about a change before you spend their money, and then making a budget adjustment is going to create a much more valued relationship with that client. And I want to throw a quote out here, and if there's anybody from my team on the line, they've heard me say this before. But I introduced one of our clients to this concept of legal project management a couple of years ago, and this lawyer had really never implemented the technique. And what he told me was, what he liked about it is that he hires lawyers based on trust. That's how he has to trust his lawyer. That's how he hires them. But what he liked about LPM was, he said, the clarity that you get out of having this plan at the beginning is essentially establishing that trust with the client. So I think that's how to answer your question about the unpredictable, I think you do as much due diligence on the front end, build that trust, build that confidence that you're providing more than just good legal service, but you're also addressing the business needs of the client.
Sounds like what you're saying is one way to address the unpredictable is really by saying, look, I don't know what the future is going to bring any more than you do, but what I do know is you can rely on me and trust me to give you faithful advice, which will be the best outcome, and we'll work through this at the same time together, which I think is what all advisors need to do.
Right.
Let's go to an Australian client perspective. Fiona O'Loughlin, whether I'm an in-house counsel or I'm a private practitioner working with in-house counsel, what's in it for me to implement LPM?
Well, I think there are probably 3 things that I think it can achieve. Firstly, I think, as David said, it's part of the ethical obligation to really unpack and understand the question at the start. Mark said you can spend a lot of time solving the wrong problem, and getting to the right question is really important. The earlier you do that, the less you burn money trying to find the question rather than trying to find the solution. I think the second thing is that with a bit of a roadmap in front of you, you can start to think more tactically about perhaps where to accelerate spend. So, you might not be at the discovery stage, but you might decide to do some deep discovery and to share some documents with the other side in an effort to settle the matter earlier, rather than wait for it to run through the traditional processes. So I do think having a roadmap will allow people to see both what the overall spend is going to be and maybe some options to try and, albeit accelerate the expend, reduce the overall expend. And I think the last thing that it offers, or from my perspective that it offers, which may not be a welcome development for external law firms, but I think it's going to come for, to us all eventually, is that it allows me to unpack the matter and decide that there are some relatively low value tasks involved in the transaction, and to either work with the existing law firm to say, well, perhaps it's not a senior associate's job to look at everything, perhaps a less senior person could do it, or to actually unbundle that work and say, well, either I will do some of that work, or in my experience, in Australia, one of the things that we're doing is seeing more what I call body shops, where very good, quite senior lawyers are available to just bring in and use on a contract basis for a particular matter or for a period. And I think that's one of the ways that we can, LPM will allow me to identify where those people would fit into a long-running large piece of litigation. So those are probably the three ways in which I see it as internal counsel assisting us in getting the most value that we can with the resources we have.
If I can pick up on your previous comments about the collection of data as well, I can see that what you're suggesting is by breaking things down, you'll be able to collect data which you can measure, and of course everything that you can measure you can improve. But one of the questions I can see on this topic coming from the audience is when we talk about basing legal costs on data, what do you mean by that? Do you mean specific data, historical data, population of lawyers? What is it and how might it be used, Fiona?
Well, I suppose it's a bit like if Amazon can predict the things that I would like to buy next, having made a single purchase or having made a series of purchases, I guess there's I think that the next generation of lawyers will expect that, well, if you've seen 100 cases and not you personally, and I think this is where actually one of the challenges will be, how do we aggregate data that we probably all hold individually into something that we could use as a common pool of information. But I think there will be, that's my prediction, is there'll be a growing expectation that, if other parts of the commercial world are doing this sort of analysis, why aren't lawyers open to doing the analysis and using the data? So I guess what I'm imagining is that they would say, well, construction case, like David said, there's been thousands of construction cases. Do you have no information about what typically happens? And can you not, put in a series of variables and spit out something that says, look, this is a best guess, which isn't just based on your personal experience or even your firm's experience, but is actually based on the experience of what has happened in construction cases in New South Wales in the last 10 years. So I don't know, I think it's an area that we just need to be open to, because the rest of the world and a lot of other disciplines are using this information, and I think it's not unreasonable to be asked, why can't you also engage in that sort of analysis?
And just on that question from the audience about what do you mean by data and how might it be used, Pat Ellis, as an in-house counsel, can I just ask from your perspective, how might somebody interacting with GM, for instance, collect data? What type of things would they be looking for, and how might that data be used?
Well, I think, as Fiona said, a really simple example is, go back and look at 5, 10, 20 matters that are similar to the one that you're trying to get work on, and look at those, look at the different variables, figure out what drove the cost. So there's a lot of financial data that can be obtained from historical matters and put to use for future matters. There's also non-financial data. So who was the judge? How many associates did you have on the case? Who was, in what jurisdiction was it? So all these, there's so much data that we can, sort of harness and bring to bear on to augment our legal expertise. And, you don't need technology to do it. Excel's technology, but you don't need anything fancy to do it. You just need to gather that data, put it into charts, put it on a table, and use that to augment your experience. That, from my perspective, if you bring that to the table, that's more than enough.
Pat, I'm amazed to see what it's like at GM, because I can tell you some lawyers I've dealt with consider Microsoft Excel to be positively magic. Before we move on, let's go to our last speaker on this topic about what is legal project management. Mark Walsh, what's in it for me? Why should I implement LPM?
Well, Philippe, I think it's true to say that without a plan, it's all a dream. That's really a defining and simplistic approach to it. LPM is a process that I'm minded from what Pat just said about Michael Lewis's book Moneyball to think of what Tversky and what Heineman and Tversky did in Michael Lewis's book, The Undoing Project. It's well described there, and that's to address biases, hindsight biases, and the halo effect, so that you look at the individual dispute with the benefit of past information. So this legal project management approach, as we call it in this seminar, allows you to approach a problem from two perspectives, from the client's perspective and from the lawyer's perspective. And it's important to understand that each of those parties have a very different set of drivers. The commercial perspective is very much with a view to duties to the company and its shareholders, and the legal practitioners, it must be remembered, have a paramount duty to the court and the administration of justice. Legal project management allows easy and early communication between those two different interests to avoid a tension arising down the line. So I think it's a very important aspect of the art of this process. But I will say this, that I think it's really important to identify legal project management as an organic process and not a perfect process. It's often known that plans are really good until you get to court or you meet the opponent, and then things have to change. And I'm very taken by the saying that a perfect plan is like a unicorn, because anyone can tell you what one looks like, but no one has actually ever seen one. And it's the same with legal project management. Under the legislative provisions, legal practitioners in Australia not only must provide an initial estimate and disclosure, but they have an obligation to provide ongoing updates to changes to anything previously disclosed. This avoids surprises and unhappy endings when the bill comes in greater than expected or the outcome is different. So that's my view of it. Thanks, Philippe.
Thanks so much, Mark. So let's move on now to our third and final topic, which is how does legal project management help to recover fees for successful litigants? Let's start with the American attorney experience, bearing in mind what the in-house counsel have been talking about, that legal spend is an investment. So David Roof, how do you maximize your return on investment through the recovery of fees?
All right, so I'm going to, since we have the American rule in place, I'm going to start with just return on investment from a lawyer's perspective. You know, Mark talked about the two interests that are being served, and I can tell you from an outside counsel standpoint, having this type of approach helps us also optimize our resources to make sure that every hour that an individual is working is productive and is not something that the client is going to view as wasteful and a write-off. I also think, you know, we had a webinar last month for our ABA LPM interest group, where we had a malpractice insurer talking about how LPM helps avoid malpractice claims because it fosters better communication both with the client and the team. So I think there's a return on investment there. When you come to recovery of legal fees, you know, in the U.S., I talked about the American rule, but there's exceptions to that rule, as I think we talked about, which are if you've got a contract in place where the parties agree that the winning party or losing party pays the other party's legal fees, where you've got a statute in place that allows the recovery of attorney's fees to the successful litigant, or where you've got punitive damages in play, and there's an award of attorney's fees as a result of the actions of the opposing party. So, you know, in those contexts, there is something very similar to the Australian practice. And when a court is looking at an award of attorney's fees, there's a reasonableness standard that they apply. They look at whether the hourly rate was reasonable. They look at the hours, whether those were reasonable. And then they look at whether or not there are any factors that would justify an adjustment up or down in the award. And so, to my knowledge, I don't know that legal project management has yet been used as an argument for the reasonableness of a fee in that context. But I think all of the things that we're talking about here, where a collaboration between a lawyer and their client results in a more efficient management of the case, I truly believe that there's an argument there that when you implement this approach and you maximize the resources and you deliver the services efficiently, that there's an argument that the parties have controlled those costs, and you might see a smaller adjustment downward of the fees. But like I said, it is yet to be established, but I'm very, since we've talked about this concept for the past 4 or 5 months, it's intrigued me, and I'm interested to see how that evolves.
Thanks very much. So, recovering fees from the Australian private practitioner's perspective, Mark Walsh, how do in-house counsel maximise their return on investment through the recovery of fees?
Well, there are 4 areas that are particularly pertinent, Philippe. There's security for costs, provisions in legislation and rules. There's an offer of compromise regime or regimen which allows a reasonable offer to be placed early on in the proceedings, and if that offer is not beaten by the other side, that has consequences. But there's also at the back end lump sum cost orders and cost orders against non-parties. Let's look at security for costs in the brief time we have available. And that's a provision that makes legal project management particularly pertinent to the costs area. This is an application which is made under the rules to guard against a impecunious shell company bringing proceedings against a wealthy defendant, and it allows the defendant to identify the risk that if the proceedings are unsuccessful, there will be injustice because the defendant won't be able to recover costs from the plaintiff, the shell plaintiff. And the court will take into account various considerations such as the prospect of success of the proceedings, the genuineness of the proceedings, impecuniosity, and other areas such as whether it's unfair that such an order should be made. And then the defendant must show what an estimate of the fees to be incurred will be. So very early on this must be brought because delay precludes this order being made, but successfully made, the court will order the plaintiff prior to prosecuting the proceedings to provide security for the defendant. So it's easy to see how legal project management informs the content of that application or notice of motion and the affidavit evidence.
Mark, thanks very much. Security for costs is something seems to be very different in Australia to the United States. Just very quickly for that, because I know I've had to explain it myself to US attorneys, could you just cover that one more time, very, very briefly? How does security for costs arise? Where does it come from? And what do we need to do in Australia about that?
Well, it arises under the rules, and it has underpinning the provision, the desire that unsuccessful proceedings do not occasion injustice to defendants by being unable to execute cost orders, compensatory cost orders against the plaintiff because the plaintiff is a person of straw. Now, there are other provisions under Section 98 of the Court Procedures of the Civil Procedure Act in New South Wales that allow the corporate veil to be pierced to go through to directors for cost orders. That's a different area. But the essence of security for costs is for the court to identify that this plaintiff must put some money where its mouth is, rather than the risk of no downside for an impecunious plaintiff bringing proceedings, or a shell company set up for the purpose of the litigation, funded by others. Thanks, Philip.
So much, Mark. Let's go to Fiona O'Loughlin. How does legal project management help in the recovery of fees from the perspective of an in-house counsel?
I suppose it gives me a likely outcome, not the only outcome, but certainly a likely outcome. And then from there, we can start to have a conversation about, well, what's the next best alternative to that likely outcome? And I think the second thing it does is really helps when trying to frame up one of, as Mark referred to, an offer during proceedings that will give me some cost protection. So to put an offer of compromise on early in the proceedings that is sufficiently large that we think that the other side are not going to achieve a number that's higher than that if they proceed with the litigation, and therefore we will recover a higher amount of costs at the end of the matter from the other party. And in order to do that, I really do need a roadmap of what's likely to unfold and how much it's likely to cost, and therefore actually be able to analyse, well, what is the cost benefit of putting this offer on now? So it's really around that, just understanding how the matter's likely to unfold, and therefore what levers I have to pull to change the outcome, both obviously in terms of the complete piece of litigation, but also in terms of our cost position.
Yeah, thanks very much for that. And finally, our last speaker on this topic, Pat Ellis. From your perspective, how does legal project management help GM get a return on its investment?
Well, I would just agree, I would agree with everything Fiona said. It provides predictability, transparency, it helps with decision making. Bottom line is, we talk about legal project management in terms of budgets and financials, but at the end of the day, these are really strategic products in a strategic process. And so going through that process, thinking about it with this kind of rigor that LPM provides is really, it leads to better outcomes, full stop.
And can I ask you, Pat, from your perspective, litigation is certainly a tool in a box for the legal department. When you're looking at your own clients' objectives, you've got a number of tools or levers to pull. Is there anything that you might suggest that an external counsel might read, look at, and get some ideas on how to interact better with somebody on the inside?
Yeah, I think, litigation is a tool and hopefully the last tool in the box. But I think we also need to consider, when I'm working with my clients internally, we consider regulation, public policy, contracting, and to that end, Richard Schell has a really great book. It's called Make the Rules or Our Rivals Will, and it covers those 4 domains and how they can be used interchangeably to achieve outcomes.
Well, Pat, thank you very much. I would like to thank all our panelists today. Thank you very much. We're coming to the end of the conference. I've got one question from the audience, which I'm going to pose to you, which is the obvious one is, I'm interested in learning more. What do I do now? Pat, we've heard from you. There's a particular book. I'll post that up as a chat message. But can I suggest, let's say, Fiona, what can I do now?
I think I'm probably the wrong person to ask, because I certainly don't hold myself out as a project management expert, other than to say, start the process. Even if it's just, pick up the last 3 matters as Patrick suggested that you did that were similar, and actually start to unpack them and analyze them, and pull out your latest piece of technology, Microsoft Word, and open a table and just do a comparison and start to see what are the similarities and what are the differences, the variables that made a difference.
David Ruth, I'm interested in learning more about LPM. What do I do?
I agree with Fiona. This is, you don't have to have a piece of technology in order to do this. What I will say is that for outside counsel, having a process to follow that they can integrate into their practice. We've talked about a lot of concepts here today, but there are workflows out there that have been developed that can help lawyers integrate this into their practice, checklists that can help them identify the things they need to communicate to the client. So, you know, there's our ABA Law Practice Division LPM Interest Group has a lot of resources. We have several webinars we've done over the past 2 years. It'd be a great place to start. If you go to YouTube and search for ABA Legal Project Management, you will see those webinars as well as this one. So that's a great place to start. And I think in several of those webinars, we reference other resources, materials, and consultants who work in this area to help both in-house counsel as well as law firms adopt these approaches. And Mark Walsh, last word from you. Interested in learning more?
It's a mark of David's modesty that he didn't mention the book that he's written on implementing legal project management, which I found a great resource. That's a book that he's written with Susan Lambreth and Aileen Leventon, and I found that particularly useful. Aileen was out in Australia and addressed the Australian Bar Association, the New South Wales Bar Association Costs and Fees Committee. That's a good resource. I found that particularly an easy way in, so to speak. It matches up with what we call case theory, and there are other resources that I think merit review, but that's a good starting